The time is 1:33 p.m. and we are now back on the record.
Okay, so I'm going to pull off this document that you sent to me. It is a 9-page document.
H2. Keep scrolling.
Oh, I see. Okay. Right.
Didn't show up there.
I'm looking. Let me scroll down a little further. Okay, I see
Right
on the
there.
next page. Yeah, okay. So the next page, 1221, cashier's check, 63,252, 46 for December 21st. Okay. Thank you. Yeah. So, all right. Right. So then, so this basically ended up in the same place that the Buena Vista um, bill pay ended up. So they basically in the same place. So Magnolia gets paid off just like Buena Vista is paid off. Same idea, right?
Correct.
Right. You happen. I get back to this screen one more time on the.
We're going to mark this as exhibit number 9.
That's exhibit number 9. I'm sorry, did I cut you off?
No,
Okay. So I'm going to get back to this folder, Dropbox folder, and I have information. Maybe you just confirm it, and we'll save ourselves some time. That on 5/11/2021, that a cashier's check was sent to Marwan's attorney in the amount of $70,542.65 as a payoff for UKIPA. Does that sound correct to you? Or can we
I,
confirm that by looking in here somewhere?
Which year?
It was paid off in 2021.
Go do the same thing.
what document, what exhibit are we talking about?
It's a new one.
Yeah, we're going to
Okay.
find out as soon as if he's able to point me to the right document, then I'll put that in.
Okay, because I don't, you asked a question and I can't, don't have anything in front of me to kind of orient myself.
Sure. So, Mr. Masloub, I was just saying, so where would I go to go ahead and confirm that that's what happened? I'm assuming it's somewhere in here.
What property are you talking about? I'm sorry, I'm kind of losing it.
No problem, no problem. That's I understand now. That's how I feel. On May 11th, 2021, a cashier's check was sent to Marwan's attorney to pay off the UKIPA loan.
Yeah, it was the attorney. Does it say who the attorney is?
Well, it's Mr. Awad, I believe, isn't it? I'm just saying
Okay.
it by memory.
Okay, well, it is a WAD, but I'm okay. Never mind. I'll wait for your question.
So you're asking me to help you navigate, right?
Thank you. That's all. I'm just trying to get there fast so we can get out of this. This
Go
part.
to the folder #01 WFUKPA.
Okay. Okay.
Go to the we have a folder called Reconciled
Okay. 2021.
2021. The month of interest to you.
5/11/21. Okay. Thank you. Yeah, that's a lot faster. Okay. Okay. So
The
this
wire
shows.
from escrow. Okay, got it. Thank you.
All right. So, all right. So the wire comes in, and that's the sale, the actual full-on sale of UKIPA, and escrow wires the money into this account. Correct?
Correct.
Okay. And then it shows a withdrawal made in a branch store for 70,542 and 65. And now I don't know if that's converted into a cashier's check, then we can't really see that right here. But but do you have any reason to think this is not the payoff for the UKIPA loan?
Well, I think the question calls for, Lax Foundation calls for speculation as to what that payment was made, unless we can have him orient himself.
Okay. So there was a football game with the money for UKIPA. Unilaterally, traditionally I do the accounting and I do the tracking. I would make a payment out to Mr. Solomon. He will make a payment out to me. And if we're paying Marwan, he makes the payment. But it has to be by convention that we do it. We had already established the convention. Now, on that day, we were so excited about making so much money. Somebody was so motivated to do it unilaterally. I do not know what happened. All I know, these are the transactions that took place. 70,542 probably went to Awad. I never saw a message from Awad saying he received it. And then 284,000, I do not know how they were split out. I got a big portion of it, half of whatever it was. And Mr. Solomon got the other half.
Okay, so out of that 284 and 22,000, I'm sorry, $284,020, you do recall getting half of that, getting paid half of that.
Objection, that misstates his testimony. He says he doesn't know how this happened. It lacks foundation, and based on his prior testimony, it calls for him to speculate.
Yeah.
So if you understand the question, do you recall receiving half of the amount of $284,020 at the time?
No, the check I got was a rounded number. It's all zeros. So I do not know exactly how it was divided. I'm not the right person to ask.
So the check that you got, was it close to half of that amount of the 284,000?
I can't remember, honestly. I don't keep track of these little things.
Well, if it was really off, you would probably remember, don't you think?
The whole thing was off. The $352,000.
Do you have any reason to suspect that Mr. Solomon got more than half of that for himself, of the 284?
I don't suspect that.
Okay, I'm going to, this is the May statement, 2021. Did you say that this particular account and statement is it's for UKIPA, correct? It's the UKIPA account, correct?
Well, we got it from a UKIPA folder. Yeah.
Okay. So just so I have a name for it. So it's the UKIPA bank statement for May of 2021. And I'm just going to make sure everyone gets a copy. And this will be Exhibit 10. Make sure there's a couple of things I was going to ask you about. I think we already talked about this. I don't need to spend a lot of time on this, but
Sorry, Council, I can't hear you. Your audio's muted or muffled.
how about now? Is that
That's
any better?
better, yes.
Okay, I guess I need to face the right direction. Okay, so I just the information I have, and I think you may have already testified to this. I just want to get rid of this, make sure I don't spend a lot of time on it. Do you remember where you were when you and Marwan signed the TD Ameritrade application to set up that account?
I was in California, somewhere in Southern California. And the late 90s.
And he was with you at the same location?
Yes, because we had a business in the beginning of the deposition. I declared we had a business of selling computer parts overseas, and this was his business account in the US.
Okay. The next one, I just wanted to clarify a few things on the Wells Fargo. On that one, Marwan's the sole owner, and you just have the power of attorney, as I understand it. And I have a note that that was opened up around December 15th of 2009. Is that about the right time frame for that Wells Fargo account?
I don't remember when it was opened, but it was in the 2000s.
Do you remember going to the location with him? And you both
Yes.
there?
We
Okay.
went to a location in Canyon Crest, Riverside.
Okay. I want to talk a little bit about now about this complaint that Marwan filed, and so I want to bring it up on the screen. I don't think I need to make it a exhibit. Let's see. Okay, are you able to see the screen?
Yes.
Okay. So this states that it was filed February 15th, 2017. And I'm not going to spend a lot of time on the causes of action. I just want to talk a little bit about some of the things he says here. Maybe you can clarify if he's telling things accurately. Down on the statement of facts, hold on one moment. So down here, if you can see that, it says statement of facts. Some of the things I think you told me already, but I just want to make sure that it's accurately stated on here. It says in or about, this is paragraph 10, in or about December 2009, plaintiff executed a durable power of attorney whereby defendant Maher Masloub, in his individual capacity, was authorized to act in the name, place, and stead of plaintiff with respect to banking transactions as determined by the parties. Is that accurate?
That's not accurate.
Can you tell me what's not accurate about it?
It is basically a power of attorney for Wells Fargo bank accounts only for those two bank accounts. Because that's part of the banking mechanism when you want to assign a power of attorney on an account.
Are you saying that these powers of attorney were the ones that were created by the banks themselves at the time?
Correct.
You had no independent power of attorney outside that?
I didn't have one, no, not to my knowledge.
Do you by chance have a copy of the ones that the banks generated in these cases?
No, I'm guilty of that, not keeping
Okay, so
records.
he's basically saying you got more power than you did, basically.
Correct.
Okay. All right. So then it says at several face-to-face meetings in 2009 and 2010 between plaintiff and Maher Masloub at the defendant's home in Riverside County. Defendant enticed plaintiff to offer him a commercial loan for defendant's use in purchasing, renovating, improving parcels of foreclosed real property in Southern California. Is that an accurate?
Not in 2009 and 2010, no, it's not accurate. But when I represented something like that, it was based on ideas that Mr. Solomon had proposed to me, and I looked at possible using Maher Masloub as my one of my source of funding at that time. That was in 2009, 2010.
So it's the years that are the problem per se? It's the years, or
Yeah,
is
it's the
Wait for me, attorney.
Oh, sorry.
I apologize, Mr. Reporter.
okay. So what years should that say, just so that I understand? It's the
I would say 2012 minus 1 year.
and this conversation you're saying was pursuant to you talking or working with Mr. Solomon. So this represents a conversation you had in that context, that you're talking with Mr. Solomon and you're trying to arrange funding, and this is what happened in 2011, 2012.
In general, yes.
Okay. And to say enticed, other than that sounds a little shady, but I know that's enticed is probably not a strong word, but you
English is
talked
my
to him
third
about-
language.
Yeah, basically you had a conversation and about commercial loans for purchasing, renovating, and improving parcels of foreclosed real property in Southern California. That part actually is correct, right? In terms of the nature of the loans.
It was just to be a bank,
Okay.
not
He's gonna be
foreclosed
a-
properties, nothing. You know, foreclosed property would have been one of the products to play with.
So Marwan's supposed to act kind of as the bank, the fund, the where you get the money for this stuff,
Correct.
right? And you are more like, and so how did you intend that to work between you and Marwan? Because since most of the money or close to all of the money was his, what was your role? I mean, how are you and Marwan working together? Were you working together as sort of, I don't want to say a word that kind of working together like sort of a partner arrangement, or how would you describe that?
I'm going to ask you to just rephrase one question. There's about 3 or 4 questions in there. I don't know which one he'll be answered, and the record will be confusing. And I apologize. I don't like to rephrase my stuff, but I'd like you to do that if you can.
So how would you describe the relationship that you had with Marwan, since he's the one with the money and you're sort of how would you describe your role in that context? He's got the money and you're what?
I am his brother.
Yes.
I help him. That's all. In this relationship with MJ Venture,
Mm-hmm.
I had no interest whatsoever from whatever he earned, not a penny. I didn't have a partnership in the background with him. I didn't have any of these agreements with him. All I did is to facilitate MJ Ventures process. Is I convinced my brother Maher Masloub to help us source the funds. My job was to help, being a partner in MJ Venture, to be very diligent about how much we were expending on the thing to minimize the cost. That was my benefit, because the more I minimized my cost and quickly got the properties rented, the more I made money from MJ Ventures. I didn't have to make money from my brother.
Okay, so
I had no partnership with my brother. There was no financial incentive other than making profit within MJ Ventures.
Okay, so your profit comes from turning the homes over and getting the whatever equity you can get out of the sale. So you've got plenty of incentive, I'm saying. It's just that your relationship to Marwan was basically making that connection. Would that be a fair way
That's
to?
all.
Okay.
Yeah,
Okay.
helping my brother. He's not sharp with money, so
Okay. Number 12, defendant Maher Masloub represented to plaintiff that purchase of foreclosed properties could be made at competitive prices, and after renovation and improvement, the properties could be either sold or rented to third parties, generating a handsome profit. That sounds consistent with your conversation?
no.
Where's this wrong?
Well, Sadar is not sold or rented. It's however it makes money, right? And competitive prices is me negotiating, and I do not know if Mr. Solomon will attest. I used to milk every dollar, especially on the first three properties, and made sure that we didn't spend extra. That was the value I bring in. I did not present MJ Ventures to my brother as something will give him handsome profits, because I know what risk and reward, and I understand exactly what long term versus short term is.
Okay. Paragraph 13. In or about December 2010, as a result of the representations and promises made by defendant Maher Masloub to plaintiff and defendant entered into an oral agreement whereby plaintiff agreed to make a commercial loan to defendant Maher Masloub under the following terms and conditions. Well, first of all, around 2010, he agreed, you had an oral agreement, and he agreed to make a commercial loan. Is that aspect accurate?
Correct.
Okay, then I'll just move on. And the terms of under the following term. The loan funds would be used exclusively for the purchase, renovation, and improvement of foreclosed real property in the Southern California region. Is that accurate?
There was no terms on Southern California region, but that's what happened. That's what we practiced.
Okay, and then the interest payable at 6% per annum on the unpaid principal balance.
Compounded.
Does compounded contradict this, or is that just more information?
6% simple is different than 6% compounded. So he was getting a very good deal.
Okay, well, okay, you're saying the agreement was to give him compounded interest, but this is only saying simple interest? Does this imply simple interest the way we're reading it, or?
No, in terms of, I'm re-emphasizing.
I'm going to interject. This is a pleading, not necessarily the truth. So
Right.
You're asking him to verify what was pled by his brother, the plaintiff, and his attorney. So I don't
No.
think that's really a fair question.
That's not accurate. I was asking him if the statement is true. If it's not true, it's not true. If it is true, it is true. I don't care whether it's true or not. I just want to know, asking you what's true.
Okay. The true, if this is a 6% interest commitment, has to say simple or compounded. I would not say 6% by itself.
Okay. If you do that, then it becomes ambiguous. Would that be fair? It doesn't tell you enough information. Okay.
Correct.
Fair enough. Okay. Interest payments to be paid by defendant to plaintiff on a monthly basis based on the aggregate amount of loan funds advanced to defendant at any particular time. Does that make sense, first of all, to you?
Interest, can I repeat it loud?
Please.
Interest payments to be paid by defendant to plaintiff on a monthly basis based on the aggregate amount of loan funds advanced to defendant at any particular time. Okay, this is false. There was no mention of monthly. Monthly was not a monthly basis at all. And by the way, MJ Ventures for 3 years didn't pay the interest. We held on it, and then we paid compounded interest on the balance of all the income that was due to my brother, all in one lump sum. For 2 or 3 years, we didn't pay anything.
When you say lump sum, you don't mean after selling the property. You just mean that things built up and then you did it all at one time.
Right.
And it covered a period of time in the past, right? Multiple months.
Correct. Probably around 2014, we start fleshing out what our liabilities, what accumulated interest and what accumulated principal due to Maher Masloub, and we paid him, and we started doing a periodic thing. It wasn't monthly. We averaged probably once or twice a year at best, once a year at worst.
Okay. And then it says, after the full complement of loan funds had been transferred to defendant, the outstanding principal and interest then due and owing would become due and payable within 30 days upon demand by plaintiff. Is that, do you recall that being part of the agreement?
I'm reading.
Sure.
There was no 30-day terms in any one of our agreements or conversations. This is long-term debt. You don't pay in 30 days.
Okay. Okay. Paragraph 14. Utilizing the power of attorney previously executed by plaintiff and pursuant to the oral agreement entered into between the parties, defendant Maher Masloub, in his individual capacity, withdrew funds from plaintiff's sole property account at United Nations Federal Credit Union, commencing on March 6, 2012, and continuing through August 9, 2014, with total withdrawals equaling $484,990. Is that an accurate?
There were transfers from his United Nations Federal Credit Union with his permission. I had access to his account. I did not have a power of attorney on the account. He knows, and he got transferred when we needed the funding. So, very concrete example, we're bidding in the auctions in 2012. We needed, let's say, $60,000 worth of $10,000 checks. We had to have that. We transferred that money and hoping that we get one or two or more properties. And that's how the aggregate transfers were of $484,900. I cannot verify the $484,990. I stand corrected here.
Okay, and the period at which the funds. So I'm saying the funds ultimately began in this United Nations Federal Credit Union. That's where they originally originated, Marwan's funds.
He's employed by an international organization, the United Nations, and that's where his salary and savings are. Those would get transferred to his Wells Fargo account. So you had full accounting of that.
Okay, so that's the origin. It ends up in the Wells Fargo account that's in his name with you, power of attorney, and then from there, the investment activities take place. Is that fair summary? Okay.
Correct.
And you're saying you've never been able to verify that $484,990 is valid? Do you have any opinion as to whether that's close?
I never looked at it. When we needed money, we transferred only with his permission. He moved money. I do not know anything about it. It might end up in the same account. I never accounted for that. It's none of my business.
Okay, so you had access with his permission, but you had no power of attorney. So would it be fair to say that when you were dealing with UNFCU, they just assumed you were him because that's he gave you permission. That's the way it was, the arrangement?
That's right.
Okay. All right. Paragraph 15. Defendant transferred all withdrawals from plaintiff's UNFCU account into a separate checking Wells Fargo Bank in Southern California, for which defendant also had power of attorney. That seems to be correct. Is that accurate at that point?
That's a correct statement.
Okay. Paragraph 16. On or about March 8th, defendant Maher Masloub, on his own behalf and on behalf of the business MJ Ventures, commenced making transfers from his Wells Fargo checking account for the purpose renovation and improvement of parcels of foreclosed real property in Yucaipa and Barstow, California, with the final withdrawal allegedly for said projects made on August 22nd, 2014. So a couple things. Those dates represent the beginning and the end of what happened. Would that be correct, at least?
The beginning and ending of the funding process, yes.
Funding,
For
okay.
all the properties MJ Ventures acquired.
Okay, and now for the rest of this, is there other things in here that you consider inaccurate, or is this accurate?
The dates are approximate in my mind. I will not contradict them.
Okay,
What about the other stuff in there?
I'm sorry.
Well, I mean,
We did purchase, renovate, and improve
okay,
parcels.
okay.
Okay. Paragraph 17, on or about April 8th, 2014, defendant provided written notice via email transmission to plaintiff of the condition of each of the properties for which loan funds were allegedly utilized, and assured plaintiff that defendant would stand by the terms of the parties' oral agreement. Is that an accurate paragraph?
That's condition, okay. I probably on that date give him some spreadsheet that I built for him so he can get an understanding of those properties as a precursor to me catching up on the payments that were due to him. This is nothing assurance, no assurances there for sure. That's not accurate.
It's not accurate because the word assured is.
Yeah.
You say you didn't give him any assurance of any.
No assurance other than we are diligently using his funds, and we are going to be paying him his interest and principal on schedule.
Okay, and that was your oral agreement in the beginning,
That's right.
So so this assured plaintiff that defendant would stand by the terms of the parties' oral agreement, that seems okay, right? Unless there's
Well, no, that's argumentative, and it misstates his part testimony that he didn't assure anything, so it's not correct.
But he kind of, if I did misunderstand you, you sort of told me that, yeah, you told him you were going to stand by the terms of the parties' oral agreement.
Around April
Same
8th.
objection.
You still answer.
April 8th, around that date, I gave him probably a spreadsheet saying how the properties are, where they are, and what they are, how much are they rented for, and so on and so forth. That things will not show up on a balance sheet or income statement. You know, it might show up on an income statement. He's not going to understand what's in it. So, and I told him that we are really doing well, and we will be paying on, we'll be paying the amortized scheduled payments.
Okay, and now it says on paragraph 18, on or about August 11th, 2014, plaintiff met with defendant at defendant's residence in Riverside County. Do you remember him being in town on August 11th, 2014 and meeting with you?
Probably he was visiting then.
Okay, at which time defendant once again assured plaintiff that he would honor his commitments as made in the oral agreement between the parties. So is that, do you disagree with that statement?
I don't remember talking other than he was probably visiting me that week. I cannot say anything else about this paragraph.
Okay, during this meeting, paragraph 19, defendant Maher Masloub represented to plaintiff the loan funds had been and would continue to be used exclusively for the purchase, renovation, and improvement of foreclosed real property, that he would make timely interest payments, and he would pay the outstanding principal balance and unpaid interest within 30 days upon plaintiff's demand for repayment. Is that accurate?
Some of that is asked and answered in other questions, but you go ahead and answer, please.
Paragraph 19 here is, I don't remember this conversation. I'm sure we touched on things, but it's redundant with everything else we've talked about before.
Yeah. Okay. And 20, in subsequent telephone conversations with plaintiff between August 2014 and April 2015, defendant reiterated he would honor his commitments as made in the oral agreements between the parties. Were there subsequent phone conversations that reiterated stuff that you had talked about in the past? I guess this would be my question.
Yeah, I mean, he was my brother. he was, I talked to him once a week or so. We can reiterate all we can reiterate. It'll be redundant.
So now, was he? Do you recall around this period of time? Do you recall whether he was acting extra concerned, overly concerned about
No,
getting paid?
no, not at all.
Did he ask you as late as April 2015? Did he ask you about payments?
No, he was getting deposit in the Wells Fargo account.
Okay. Now, he was getting the deposits according to what you're saying, but you guys just didn't talk about it, right? Because he never told you he was getting deposits. It's just that you assumed he, right?
Wait a minute. I'm going to object. The question is argumentative. It's been asked and answered in prior questions, and it's compound. You go ahead and answer.
Well, except that he made the statement again. So I want to make sure I'm not missing something.
I understand. I'm just making my objections for the record.
Okay,
The
no, that's
answer
fine. I
is-
thought you told him not to answer. I was wondering.
Oh, no. I said go ahead and answer.
Oh,
I mean,
I
that would
apologize.
be
Thank you.
ridiculous.
I didn't know. I'm asking. So,
No, I'm just saying
okay,
that
so
I want
yeah.
him to answer. I don't want to tell him not to answer, except for that one question. I don't like him. You don't like him, and I'm trying to keep my mouth shut, but it's awfully hard sometimes.
This is redundant. I don't like redundancy. I don't remember what I told him in August 2014
Okay.
on the phone or outside, on the phone calls or anything around that phone calls.
Plaintiff relied, paragraph 21, on defendant Maher's representations. Hold on. I don't think I need to talk about that one. That's an accusation. Hold on. So I get that here so I can go faster here. It says in around April 2015, paragraph 24, and pursuant to the terms of the parties' oral agreement, plaintiff made demand on defendant that defendant repay the principal outstanding balance of the loan together with interest on the unpaid balance within 30 days. Did he make a demand on you in April of 2015?
It wasn't in April 2015. It was somewhere around September of 2015 because he lost his job.
So he made a demand around September of 2015. And do you remember, was this over the phone?
No. He came in August, mid-August of 2015 from a travel. It's one of the reasons why I stopped trusting his judgment. Not the money at all. It was he sent his children, one of his children, a child, to my house the whole summer while him and his wife were entertaining himself in a war zone in Syria during the civil war of Syria, without telling me when they send their child to my house to stay with me that they are sitting there for 2 or 3 months. And when they arrived to my house in August, I was not very impressed with their judgment about that situation. And I started really, I'm his older brother, and we do that in the Middle East. We badger them. Why did you do the idiot thing? And that's when he started telling me. He didn't tell me he lost his job. He started telling me he wants his money.
Okay.
Then I said, tell him this is real estate. You don't liquidate real estate by a blink of an eye.
So how long was this conversation? Do you remember? It was a conversation that you had with him at this time, August, September of 2015?
In around August of that year, I spoke to him one night and I stopped talking to him for the remainder of 2 or 3 weeks.
What did you tell him about? I understand you just said this is real estate. So it was unreasonable, I'm assuming, to expect such a quick payment. But what did you tell him you were going to do to, if anything, to
I told
accommodate?
him this is real estate. He will be foregoing his future income. He is actually jeopardizing the selling price by demanding it immediately. And it's not wise to ask for that money. And I asked him, how come he has a great income? He might have had his own personal reasons, whatever that is. He wouldn't give me an answer. But then later in February of 2016, I found out that he had lost his job.
Oh, later, okay. You didn't tell him at the time that whatever payments he's going to get is going to stop, though, right? You just told him, I'm not selling the properties, I'm not going to damage the value of the properties by rushing along those lines.
Correct.
Okay.
I did not threaten him in any way that he's going to lose his income or the recurring flow, but it is not practical for him to expect immediately that we liquidate the assets. It's not good for me or for Jay.
Okay, so basically, this next paragraph is basically saying you refused to pay him, but I'm just going to assume that you because that's not in the best interest of the business, and that wasn't what you agreed. Therefore, that wasn't going to happen. Fair enough in terms of.
Objection, that misstates his testimony, and it's
I thought it was being nice.
and a narrative, and it's compound.
Okay, well, we can do it the long way, I guess.
We can skip the
You
paragraph.
told him no. I'm not selling the properties, right?
We said it's not practical to sell a property immediately.
Okay.
That's
Did
the
you make
advice.
did you make any arrangements to market the house in a way that you felt could get a higher price, or did you just not market the house?
We didn't market the house.
Okay.
But if you know historically, we sold houses and we gave him the money.
He says plaintiff is informed and believes, this is paragraph 29. Plaintiff is informed and believes, and based thereon alleges the total of loan funds withdrawn by defendant from Wells Fargo branches for defendant's personal use and enrichment is approximately the sum of $121,300.08. Is that an accurate statement?
It's a false statement.
Do you have any idea where he got that figure from?
I never had any chance to discover that part with him during the trial.
When you say trial, you're referring just to the general litigation?
This case that you are reading the complaint for.
Says defendant eventually made an interest, this is paragraph 31. Defendant eventually made an interest payment on or about February 26, 2016, at which time defendant deposited $34,000 into plaintiff's UNFCU account. Did that happen?
From the Wells Fargo account, yeah.
I have to interject. There's some writing in red that I don't believe is a part and parcel.
No.
Yeah, right there.
No, it's my notes. Let me just make that disappear.
Okay, I just want to make sure that that does not go into the exhibit. Sorry.
No, I actually wasn't even going to put this into the exhibit. I just figured we'd talk about it. And
I don't have any problem with that. We all have a copy. I just had never seen that, and I didn't mean to
yeah, that was me
intrude
making
upon your
notes.
thoughts.
Yeah, no problem. Okay, so basically you eventually made an interest payment according to this February 26, 2016, in the amount of $34,000 into the Federal Credit Union account. Did that happen?
That was a transfer from his Wells Fargo account to his UNFCU account.
Okay, so he just moved money from one of his accounts to another account.
That's right, because he was already paid. Sorry, I interrupted you.
Oh, that's okay.
Yes, he had already been paid prior to that date into his Wells Fargo account from MJ Ventures, and I transferred $34,000 for his own convenience and indulgence. It wasn't for anything to do with MJ Ventures.
So, okay. So when you receive, okay, let me just move on. Paragraph 32. On or about December 27, 2016, defendant wire transferred the sum of $27,827.66 into plaintiff's UNFCU account, 5,000 of which represented a payment against the outstanding principal and the remainder against interest then due and owing. I understand that this is a transfer from his own account to his other account. Why is he, do you happen to know why he's saying 5,000 represented an outstanding principal and the remainder against interest then due and owing?
The question calls for speculation, lacks foundation.
Yeah, I do not know what the background of this paragraph and how it relates to me being, in this complaint. The $5,000, there is no principal and interest worth $5,000 in any accounting system because there's no interest rounded to zeros. I do not know who gets these kind of numbers.
Okay, so just for clarity, it says 5,000 of which represented a payment against the outstanding principal and the remainder against interest then due and owing. So well, if you don't know what this is, then I'll just move on.
I do not know.
Okay. No further payments, paragraph 33, of either principal or interest have been made by defendant, irrespective of the continuing demands for payment made by plaintiff, and there remains due and owing and unpaid as of the date of this complaint, the principal approximate sum of $479,990 and interest accruing at 6% per annum on the unpaid principal balance.
It's all false.
It's all false? Okay.
Yeah.
Is there, now I know you mentioned earlier that he owes you money, but if you remove that money he owes you, was he owed something along this amount of money, $479,990?
Objection that's been asked and answered.
No.
Was he owed anything?
Well, that's overbroad. I think that there's been some other questions that have been asked during today about how the payments were made and the loans applied, and so I think that it's compound.
Well, I'm going to rephrase it then, but I do want an answer. He's accusing you of owing him a principal of approximately $479,990. Setting aside the money he owes you, since it appears to be unrelated, did you owe him anything resembling, I guess what I'm trying to say, this $479,990 represents money that he claims he loaned for real estate purchases. Do you agree with me at least on that point to start with?
Well, there's two questions there. But if
Well,
you're
I'm
having
asking
to
him a question, sir. I just, if you want to object, that's fine, but I don't, I sure hate him to forget the question every time I ask it.
I'm not doing it for that reason.
All right, so let me break it down. He's accusing you of owing money that he loaned you for investment purposes. Is that accurate?
It's been asked and answered.
I don't know anything about this paragraph. I do not know where he comes up with this number. I need to see the supporting documentation for this.
Did he loan you any money for the purpose of investing in real estate?
For MJ Ventures.
Okay. Did he loan you any money that was used for MJ Ventures that was for the purpose of investing in real estate?
No.
He didn't loan you any money?
No.
So you're saying he loaned MJ Ventures the money?
He loaned MJ Ventures through transfers from Wells Fargo to his account at Wells Fargo to MJ Ventures.
And this money is supposed to reflect the money that he loaned that MJ Ventures used for purchasing homes, right?
Well, that assumes facts, not evidence that this money is vague and ambiguous.
The $479,990, he's accusing you of not repaying him that money.
Again, this is a pleading, and what relevance does that have, what he said in a pleading?
I am asking a question. I'd appreciate an answer, and these speaking objections are getting out of control here, sir. I know that you're trying to draw a distinction between you and MJ Ventures, but I'm asking you, is he's accusing you this money here. You're saying this is an MJ Ventures, that this money was loaned to MJ Ventures. Would that be correct?
I will object. It assumes facts, not evidence, and it misstates the evidence and the testimony.
I haven't misstated anything. I've asked a question, and I haven't assumed any facts. I'm asking you a simple question. We can go do this all day long if you want to do this, sir. It's a simple question. I'm trying to understand what this money that he's accusing you of owing him, what is it?
From this text, I don't know anything about it, what's behind it. That's simple.
And when you dealt with him for real estate investment purposes in connection with MJ Ventures, now all right, I'm gonna save this for a moment. Is it your contention that you do not owe your brother anything, any money at this point in time? Is that your contention?
Right now, all I know is we have a judgment.
Do you consider that judgment valid?
If a judge said that and signed off of it, yes.
So based on the judge signing off on it, you owe him the judgment amount, whatever that is. Would that be accurate?
I don't. No, that's not accurate. MJ Venture owns them.
But you were also sued individually, correct?
I do not know the terms of the legalese part of it. I cannot answer that question.
So, okay. So you think
Because it
MJ
was
Ventures?
Okay, go ahead. Sorry.
So your position is MJ Ventures owes him that money, but you do not personally owe him that money?
Objection may call for a legal conclusion.
Well, you kind of opened the door. I want to understand what you're saying. You're telling me MJ Ventures does, but it sounds like you're saying that you personally don't. And then you said if the judge says I do, but then I say the judgment says you do. So I'm asking you, do you acknowledge that legally you owe him money individually?
Objection calls for legal opinion. It calls for expertise, lacks foundation.
You can answer the question still.
And the judgment speaks for itself.
That's fine. It's an objection. You can still answer the question, sir. And if
I
you've
do
forgotten
not
the
know
question,
where-
I'll have it read back.
The numbers in paragraph 33 means nothing to me. I do not know what they mean. I don't have the background of those numbers. So I cannot tell you it's mine or not mine or somebody else's.
Okay. One moment.
Is there a question? Sorry.
No, I said, give me one moment. I'm going to
Take
pull
your
up
time.
a document. Yeah. Okay, I'm transferring a document through the chat. So I'm not confused. My exhibit 10, can you remind me of what exhibit 10? I do have it's dated May 2021. I'm just trying to remember what the title of the document was. Do you remember, John?
Oh, I'm sorry. Hold on, let me look at my notes. Exhibit 10 is 5/11/21.
Yeah, that's what I got too. But I don't know what the document, I don't know what this, remember, was it a statement?
I think it was a TD Ameritrade statement.
Okay.
And this is where you asked the question about checks going to Awad.
Oh, I'm sorry. No, it was just so we don't all get confused. It was the Ukaipa bank statement.
It's on
521.
the screen.
The Ukaipa bank statement.
It's on the screen.
Yeah, and I think that is
And number 9 is TD Ameritrade from 2016. So sorry, I messed that up.
okay. So what exhibit? The one you have up there. What exhibit is that now?
I pulled that one back up. That is exhibit 10.
Okay, thank you.
Yes. Okay.
See how confused I get?
Oh, I'm doing the same thing. Okay. All right. So I sent over just now the what's going to be exhibit 11. It's the settlement
Haven't we already have
Transcript.
exhibit 11?
Settlement transcript. I just sent you something in the
Okay, got it.
chat. Okay. Okay, this is a 6-page document, and I sent it to you. Do you recognize this?
This is, what kind of document is this, sir?
It says it's the order's transcript of oral proceedings, and it's in connection with the settlement agreement
Okay.
we talked about earlier that you have with your brother in front of the court.
Okay, thank you.
Okay. And this document states that this hearing took place on January 20th, 2019 before Honorable Gary Tranbarger. And I'm going to read through this so we can talk about some of the contents of it. This says, the court says, okay, let's call matter of Masloub via Masloub. Appearances, please. Mr. Awad. Akram Awad on behalf of plaintiff. Mr. Mulvana. John Mulvana for the defendant, Marwan Masloub, who is present. Mr. Maher Masloub says, Maher. The court says, Maher. Mr. Mulvana, did I say Marwan? The court, you did. Plaintiff is Marwan Masloub, present. Good afternoon, sir. So you, your brother, and both the attorneys are before the court on this day, correct?
Yes.
Okay. Now it says the court says on line 18, page 2, one of the attorneys is about to state the terms of the settlement. If you agree to the settlement here in open court, it is binding. You cannot change your mind afterwards. There will be a settlement agreement that will be drafted. You will be asked to sign it later. But as long as that settlement agreement is consistent with what we say here, you have to sign it. You cannot change your mind. So listen very carefully. All right, who wants to take a crack? Mr. Mulvana, I'm going to request that Mr. Awad say the terms. I may add some stuff. And Mr. Masloub, you're present while all this is going on, correct?
Yes.
Okay. Mr. Awad says, okay, may I proceed? The court, slowly. Mr. Awad, I'm going to use defendant and plaintiff as opposed to names. Okay, I'm going to move down to line 6. Mr. Awad, defendant is to take all actions to liquidate the TD Ameritrade account. Parenthetical 884-926379 in parenthetical forthwith. In other words, within 72 hours, wire all funds from the account to the IOLTA. Mr. Maher Masloub, can't be done. The court, just a second, off the record. So they're talking right now, the account we've discussed earlier is the account where the funds, first of all, it's the account that is owned by Marwan, and I believe you said that you're a joint account holder on this particular one?
I need to find the exact language according to the Ameritrade. I am a tenant in common.
Okay. So the payments that were made that we talked about earlier to pay off the properties, that money we're dealing with, well, I guess you can't speak to the 2 properties that were sold after the judgment, but the Buena Vista and the what the other property was. Magnolia. Those payoffs you took and deposited into this account, correct?
Mm-hmm.
All right.
Yes.
Yes.
And you deposited that into TD Ameritrade, right? Not directly into Wells Fargo. You deposited TD Ameritrade directly, correct?
Right, because I know after 2016, I couldn't go to Wells Fargo. I didn't want to go to Wells Fargo.
So would it be fair to say no payoff ever went to Wells Fargo?
No, there were payoffs that went to Wells Fargo.
But wasn't the Buena Vista and the Magnolia, weren't those the first 2 of the 6 that got paid off?
Okay. So you're talking about the closing of the loans, which is they went to Ameritrade. You are right, but there were payments and interest paid into Wells Fargo also.
Okay, so just so we're clear, some payments were made into Wells Fargo, but final payoff amounts went into TD Ameritrade.
Indeed.
Okay. Off the record, back on the record, line 13, line 14. Mr. Awad, within 2 or 3 days of today's date, strike that. Within 1 week of today, counsel for defendant will present counsel for plaintiff with a settlement agreement that will embody the terms that we're expressing here today. The terms of that agreement shall be as follows. Defendant shall liquidate the TD Ameritrade account number 884-926379, and wire $200,000 from that account to the IOLTA account of plaintiff's lawyers. Did that ever happen?
Not based on this, because the judgment was different.
I'm not asking about the judgment. I'm asking about the settlement. So
This step never took. This
never happened.
never happened. Never happened.
Okay. The account number and routing number will be provided in the settlement agreement. Defendant needs 5 business days to wire those funds from the date of the settlement agreement. Mr. Mulvena, when it's executed, Mr. Awad, the day it's executed, all tax consequences and such liquidation shall be the sole and exclusive responsibility of defendant, period, new paragraph. Defendant shall pay plaintiff $240,000 within 7 months of the executed settlement agreement. Such funds, again, wired to plaintiff's lawyer's IOLTA account. Did you ever pay Marwan $240,000 within 7 months of this date?
Repeat that question, please.
Did you pay Marwan $240,000 within 7 months of the date of this hearing?
That misstates the testimony.
I'm not quoting the testimony. I'm asking you a straight question. Did you pay him $240,000 within 7 months of the date of this hearing? I'm specifically asking you my own words.
The question is argumentative as it misstates this testimony.
I didn't, no, I'm not. I'm not quoting anything. I'm asking you if you paid $240,000 within 7 months of the date of this hearing. That's all I'm asking you.
No, we didn't.
Thank you. Okay. Such payment shall be secured by a deed of trust and assignment of rents to be filed and recorded with the following property, commonly known as 37181 Lombardi, Barstow, California, County of Riverside. Was there ever a deed of trust executed for the Lombardi property to secure the $240,000?
No.
From the date of today, defendant shall not encumber or otherwise lien said property. Period. This $240,000 payment is further secured by a stipulated judgment in the amount of $500,000. If that $240,000 payment is not made within 7 months of the date of the executed settlement agreement. Period. Court retains all jurisdiction to enforce settlement agreement. The court. One clarification, if he makes the $200,000 payment and fails to make the $240,000 payment, the judgment will be for $300,000. Mr. Awad, that's fine. Okay, so would you agree there's like, if this settlement is basically breached, then there's a $60,000 surcharge on the amount. Would you agree with me? That's what this is saying here?
That was the intent of this.
Okay, and I'm going to skip down a little bit. Mr. Mulvena says on line 2 of page 5, and the other thing is that will be a waiver of Civil Code 1542, and this will be enforceable by Code of Civil Procedure 664.6 and the release. Mr. Awad, that's fine. Let me scroll down a little more, try to get this done. This settlement agreement was never executed, correct?
Was never signed.
Never signed. Why?
Why? Why did we cross the 7 months barrier? Because
Okay.
Mr. Awad was a very undecisive attorney. He wouldn't get things done. That's one. Plus, this lawsuit that we are talking about today had commenced, and so therefore I'm blocked from paying the 7 months, paying the things that are due 7 months later. So first of all, we had not finalized the agreement, this judgment, and at the same time, I'm probably using the wrong words, by the way, and at the same time, this case of Salman versus Masloub commenced. So we got into muddier water.
So you're saying the reason you didn't do this judgment is because this separate lawsuit disrupted the settlement?
That misstates his testimony. He gave you 2 reasons.
I'm just trying to understand, trying to summarize what you're trying to say. I mean, if you're saying that the filing of this lawsuit is the reason why you did not settle the other lawsuit?
Objection, that misstates the testimony.
First, I said Mr. Awad would not do his homework, and he delayed it, and this thing was not signed by him after, I think, a period of 12 months almost. And then the judge just made his judgment, regardless of what this document shows in it. Plus, Mr. Salman initiated this case, and we had to deal with it too.
Well, without getting into legal conclusions or communications with your attorney, you're saying Mr. Awad did not have his client sign the settlement agreement? You made a statement like that. He didn't have it signed. Is that what you're saying?
He was not getting the paperwork done on his side in timely manner. It was a go back and forth, back and forth, back and forth. Never gets things done.
So you're willing to take a $60,000 surcharge because the other side, I'm just understanding, I mean, did you make any efforts to resolve this so that you don't get hit with an extra $60,000 judgment?
I'm going to object. It's argumentative. You can go ahead and answer.
Why should I take a $60,000 charge? Somebody puts his leg in front of my foot and trips me. It's called Solomon. Why should I go and say, oh, I forgive you, you're not fixing my foot or my broken knee?
So was this $60,000 surcharge you sharing that with Solomon to kind of get back
MJ
in?
Venture. MJ Venture pays it. I'll take a hit, 30,000 of it. Absolutely. I'll put that on my shoulders.
As long as you
Object.
fix it.
I'll move to strike the last part. It's non-responsive. Don't be adding stuff.
No, don't,
Just answer
don't,
the
don't,
question.
don't, you're striking your own, the client's, that's,
Yeah, I did.
yeah.
Not the first time.
Well, it might be non-responsive, but it still exists, so.
It sure does. And you'll make the best of it. So,
Are you in the room, I'm sorry, are you in a separate location? John, I keep seeing him look up, it looks like he's looking at someone, I'm just trying to figure out is someone else in the room with you?
I'm sitting at the same table. We're the only ones here. He does look up at me at occasion, and then I
Okay.
smile and I listen. But most of the time, I'm on my phone and not looking at him.
Okay, so, yeah, I didn't understand, so at least now I understand.
Yeah, we're in the same spot because when we're all remote, I never work that way. It screws me up.
Give me 1 second.
Mr. Porter, how are you doing?
I'm doing fine for now.
Okay.
Would you like to take a short one? I'm just going to review a few things. I do have to go over a few more things, but we can take a short break if that would help. And then I can probably get myself organized a little bit better and probably save some time. We do 10 minutes?
Yeah, 10 minutes is fine.
Great, thank you.
The time is 2:47 p.m. We're going off the record. Please stand by.